Bismillahirrahmanirrahim. In this session, we shall cover general introduction to Islamic inheritance law. The Prophet, peace be upon him, has said, learn laws of inheritance, ilmul faraid, and teach them to people, for they are one half of useful knowledge. Therefore, Islamic inheritance law and its knowledge is very, very useful and very important. The first question is, what is inheritance? Inheritance is involuntary devolution of property of a deceased person to his or her legal heirs. It comes into operation after the death of a person. This is a very important point because under Hindu law, the right to inheritance accrues with the birth of a person. But under Islamic law, the right of inheritance accrues when a person dies whose property is to be inherited by his or her legal heirs. Death, funeral expenses, and will are deducted before the distribution of property. So after these expenses are covered, whatever is left over, that forms the estate of a person's inheritance, which is to be distributed amongst his or her legal heirs. Inheritance applies to all movable and immovable property of a person. However, under Shia law, a childless widow does not inherit her husband's immovable property. But this principle has been disputed in a judgment of Lahore High Court, Khalida Shamim Akhtar versus Ghulam Jafar, that was reported in 2016. There was an earlier Supreme Court judgment in 1972. As a result of this judgment, a bill was presented before the National Assembly of Pakistan, and that has been pending ever since. This judgment has been appealed before the Supreme Court and has been pending adjudication. Aq or disinheritance does not exist under Islamic law. Islamic law does not allow a person to be disinherited. No person can disinherit one's legal heirs, technically called Aq, during one's lifetime or through the testamentary disposition. Despite this, we see every now and then some advertisements in the newspaper called Aqnama that does not have any legal validity. Under Islamic law of inheritance, no one is allowed to disinherit one's legal heirs. If you are not happy that property should go to a particular legal heir after your death, you can distribute your property during lifetime. And this is how you can disinherit certain persons, but you cannot write down in your will that a certain person who is a legal heir must not inherit your property. So the principle of Aq or disinheritance does not apply. When does the right of inheritance arise? Right to succeed accrues after the death of the propositus and not at the birth of a legal heir. Right to inheritance becomes vested at the death of the propositus and is not lost at the death of the heir before the distribution of the property. So if a person dies, at the time of that person's death, whoever were his or her legal heirs, they will inherit. It may happen that before the inheritance is actually distributed, one or two or more of legal heirs may die. That does not affect their right, because the right of inheritance accrues at the time of the death of the person whose property is subject to inheritance, and it instantly vested in the people who are alive at the time of death of that person. And if between the death of a person and distribution of inheritance property, some of the legal heirs die, it does not affect their inheritance right. It has very important implications because most of the time, right of inheritance accrues, but the inheritance is not distributed. Sometimes many decades pass in between this process, but it is very important to bear in mind that the right of inheritance accrues at the time of the death of the person whose property is subject to distribution under laws of inheritance. Mere expectancy to inherit, that is successionist, is not a valid transferable right under Islamic law. So I cannot sell or put in mortgage my right to inherit from either my father, my mother, or any other person's property. So successionist is not a valid transferable right under Islamic law. There is a context of Islamic inheritance law, and it is very important if we want to have truly philosophic um, understanding of Islamic inheritance law, we need to appreciate the context in which Islamic inheritance laws were first promulgated. During pre-Islamic period, females could neither inherit nor dispose of their property. Rather, they themselves were the property who were inheritable by males. A brother or stepson took possession of a dead man's widows along with his property. Adult male agnates, asaba, from male ancestors inherit the entire property. Female cognates from female ancestors were completely excluded. Descendants were preferred over ascendants. Ascendants were preferred to collateral. So descendants are the children, ascendants are the parents. So descendants were preferred over ascendants, and ascendants, parents, were preferred over collaterals like brothers and sisters. An adopted son who was able to carry arms inherited like a real son. Mutual inheritance between two men based on their vows was accepted as a valid mode of transfer of property through inheritance. However, when Islam came, it introduced certain reform in pre-Arabian customary practices related to inheritance. A surviving spouse was made an heir. Previously, a spouse, specifically wife, did not inherit in the property of her husband. Agnate females and male and female cognates were given share in inheritance. So basically, females were given inheritance in the property. Parents and ascendants were given share in inheritance in presence of male descendants. So previously, in the presence of male ascendants, parents were completely excluded. Generally, females were given 1/2 share of a male, but bear in mind that father and mother sometimes get equal share. So although it's a general principle that generally daughter will get half of son, sister will get half of brother, but there are exceptions to this rule, and there are certain circumstances when father and mother, they inherit equally. What are the sources of Islamic inheritance law? Quran is the basic source of inheritance law. There are detailed Quranic verses that we will cover in our next session. Sunnah of the Prophet, peace be upon him, is the second source. Consensus for ijma of scholars is the third source. Pre-Islamic Arabian customary practices are also important source of Islamic inheritance law. Recent opinion of early jurists, they also form basis or the source of Islamic inheritance law. So what are the general principles of Islamic inheritance law? First of all, the personal law of propositus, the person whose property is to be distributed, and not the law of legal heirs, is applicable. If a non-Muslim embraces Islam and dies as a Muslim, his property will be divided according to Islamic law, although some of his legal heirs might be non-Muslims. And by the application of Islamic law, non-Muslims will be completely excluded from inheritance. because it's the Islamic law that will apply. And under Islamic law of inheritance, non-Muslims do not inherit from a Muslim. A childless widow of a Shia husband does not inherit land, but as I mentioned, there is a 2016 judgment of Lahore High Court which held that this principle does not make much sense, and the court applied Quranic verses where there is no distinction between movable and immovable property and between child less widow. Um, and then, as a result of this judgment, a bill was presented before the National Assembly, but this bill has not yet been passed. There is presumption of sectarian affiliation because there are, as we shall see, a number of important differences between Sunni and Shia inheritance law, specifically when it comes to the right of females, and more specifically, daughters and sisters. Every person is presumed to belong to the sect to which his father belonged, unless it appears that he renounced that sect and adopted another. This was held in one judgment. In the same judgment, it was held that a woman whose father and husband are Sunnis should become a Shia in an event which is not very probable. So there is a presumption that a person continues to follow one's father's sect unless there is evidence to the contrary. This is an important question regarding choice of inheritance law. Can a person choose which particular inheritance law should apply? Registration of marriage under the Indian Special Marriages Act 1954 leads to the application of Succession Act 1925, which is a secular legislation. But certain parts of this 1925 Act with respect to succession certificate also apply to Muslim personal law or Islamic law inheritance. Special Marriages Act 1872 only available to non-Muslims. This is applicable in Pakistan. An important question is that could a Sunni Muslim, without converting to a Shia sect, elect to follow the Shia law of succession? We do not have clear judgment on this point, but one judgment of the Balochistan High Court in 1978 makes a reference to this question. In this judgment, the court held, in upholding the Muslim wife's right to arrears of maintenance, a right to not recognized by classical interpretations of Hanafi law, the Quetta High Court in 1978 specifically referred to Shia law as well as Shafi law as the source of the more liberal rule in favor of the wife's claim, and justified applying this rule to the Hanafi litigants before it by observing that there is consensus of opinion that these are only different schools of thought as far as Islamic jurisprudence is concerned and not different religions, so as to prohibit the following of each other's footsteps in some matters or principles. But still, it remains a moot point whether a Sunni Muslim convert to Shia sect or vice versa without changing one's personal belief or faith or sect. Rule of primogeniture plays very important role in Western inheritance law, where the eldest son takes all the property of his father. Islamic law does not recognize the rule of primogeniture, but it has limited acceptance for this rule. Under Shia, Shafi, and Maliki schools, the eldest sound mind's son inherits certain articles of his father, such as wearing apparel, Quran, ring, and sword, provided the deceased left other property that may go to other legal heirs. This is also important to note that heirs are tenants in common and not joint tenants with the right of survivorship, which means that all legal heirs inherit their respective shares at the same time. It's not that some of the legal heirs will have to wait until the death of certain people so that the property comes to them. In certain circumstances, there is a bar to inheritance. Homicide is one bar, murder, intentional under Shia law, and intentional and unintentional under Hanafi law by the legal heir or beneficiary of a will excludes him or her along with her or her descendants. Illegitimate child inherits from mother and vice versa under Hanafi law. Such child cannot inherit from either parents under Shia law. Difference of religion, non-Muslim cannot inherit from a Muslim. Likewise, a Muslim does not inherit from a non-Muslim. The property of an apostate is distributed to his legal heirs during his lifetime. Estoppel in succession is applied. A person who denied a relationship with the propositors cannot subsequently claim inheritance. Under secular legislation, Succession Act 1925, any lineal descendant oust any other relative except the surviving spouse. So if there are children, then parents of the person who's deceased or that person's brother or sister do not inherit. Only that person's spouse, surviving spouse, inherits. The share of the surviving spouse with lineal descendant is 1/3. Under Islamic law, remember, if a person dies, his wife inherits 1/4 if there are no children and 1/8 if there are children. If a person dies and she is survived by her husband, then her husband takes 1/2 of the property if there are no children and 1/4 of the property if there are children. Males and female under the Succession Act 1925 inherit equally, but we know that as a general rule under Islamic law, male take double the share of female. But there are certain exceptions, specifically with respect to parents who under certain circumstances inherit equally. Complete testamentary freedom to dispose of the property without consent of anyone is provided under Succession Act. But under Islamic law of inheritance, there are two important limitations. You cannot dispose of more than 1/3 of your property. And second, you cannot leave your property in favor of your legal heir unless the other legal heirs give their consent. But these limitations do not exist under the Succession Act 1925, which is a secular legislation. Customary law has historically played very important role in the application of inheritance law in South Asia. Under Muslim under Section 5 of the Punjab Laws Act 1872 and NWFP Justice Regulations 1901, customary law was given preference over Muslim personal law, which means that women were not given inheritance right in land. There was agnatic succession. All males except widows would get the property. Females were completely excluded. Females, however, were given limited life interests. Property held by females as an heir or donee reverts back to the male heir of the last male owner on the termination of the life interest. That is marriage or death. So as a general rule, females were not given inheritance rights at all. And wherever they were given, they were just given a life interest, which means that they could just enjoy the benefit of the property during their lifetime, but they could not dispose of the property. So their Islamic inheritance right was not available to them. Similarly, females do not have a right to challenge the alienation of ancestral property, which right is available to males under customary law. During colonial period, custom was tried to be limited. NWFP Sharia Application Act 1935 provided that female will have inheritance right. Muslim Personal Law Sharia Application Act 1937 provided that female will have inheritance law, but this act did not apply to agricultural land and it did not apply to testate succession, that is through will, because under the Government of India Act 1935, land was a provincial subject. Central legislation could not enact on land, and testamentary succession was in concurrent list, that is, that both provincial and central legislature could legislate on that, but in this act, central legislature opted not to legislate on that issue. Therefore, when Pakistan came into existence, West Punjab Muslim Personal Law Sharia Application Act 1948 applied this law to agricultural land, but it did not apply to testamentary succession. In 1951, West Pakistan Muslim Personal Law Sharia Application Amendment Act applied testate succession and terminated estates held under wills. A similar act was passed in Sindh in 1950. In 1961, Muslim Family Laws Ordinance 1961 provided right of representation to orphan grandchildren in the state of their grandfathers. West Pakistan Muslim Personal Law Sharia Application Act 1962 consolidated various Muslim Personal Application Acts in the West Pakistan and provided the application of Muslim personal law on succession, testate, and intestate, but it created further confusions. Therefore, a decade later, the Punjab Muslim Personal Law Shariat Application Removal of Doubts Ordinance 1971 was passed to clarify the confusion as to the life estate's rights terminate. The Muslim Personal Law Sharia Application Removal of Difficulties Act 1975 clarified that the refugee females who were allotted evacuee property were limited owners under custom. So the enactment of NWFP Shariat Application Act 1935, and then Muslim Personal Law Shariat Application Act 1937, then Act 1948, 1950, 1951, 1962, 1972, 1975, all tried to provide women right in agricultural land. And this has been subject to further legislation in Pakistan. In 2001, the Criminal Law Third Amendment Act added Section 498A in the Pakistan Penal Code, which prescribes the punishment of 10 years or fine of 1 million or both for depriving women of their right to inheritance. Legal reforms were also introduced by the Punjab government in 2012. Upon the death of a landowner, proceedings for inheritance mutation shall proactively be initiated by the revenue officer forthwith, without application being moved by any of the parties, and he shall sanction the mutation as soon as possible. The reference to CNIC and Bay form will be mandatory while sanctioning inheritance mutation, so as to ensure that no legal heir is deprived of his or her fundamental right to property. Upon sanctioning of inheritance mutation and without application from any of the parties, the revenue officer shall forthwith commence proceedings for partition of land. To further facilitate a mutation of land or transfer of land as a result of inheritance, Stamp duty has been waived for partition made effective due inheritance for both rural and urban properties, and only a token charges amounting to rupees 500 per mutation have been imposed, replacing 2% stamp duty on such mutation. In case law, we see that the various Sharia application acts and their retrospective effect has been subjected to litigation. There is still a case law on the issue of supremacy of Muslim personal law over custom, because custom continued to play a very important role. So what happened is that under custom, life estates were created in land. How life estates are created, they are created through different settlement. Say, for instance, I create a family settlement that the property would be managed by my son, then my son's sons, and then my son's son's son for several generations. Now, customary law allowed that. And since land, unlike other consumable goods, remain intact for longer period of time, so we see that some estates that were created more than 100 years ago still exist. And the issue was that when starting from 1935 NWFP Sharia Application Act and all the way to 2012 Punjab government regulations about ensuring women's right to inheritance, what should become to those estates that were already created? Do these legislative instrument apply to those settlements? And what's the impact of these legislations? Say, for instance, this 2011 Section 491A in Pakistan Penal Code. Of course, it's a penal law, it applies prospectively. But what about the other legislation? Does that apply to the transactions that had taken place before these several acts were passed? So these are some of the questions that have been continued to be litigated upon, and there are several judgments on these issues. Following Islamic inheritance law regarding women's right to inherit is declared a matter of public policy and morality by the Chief Justice of Pakistan, Justice Afzal Zulla, in 1990. And in another judgment of the Supreme Court of Pakistan, it was held that a brother cannot legally claim adverse possession against his sister. We know adverse possession principle works that if some person has the possession of a property for a certain period of time and the other person's whose property it really was does not bring any claim, then after the limitation period, which could be 12 years or more, depending upon different situation, the person who is the actual owner of that right cannot bring a claim. So this is called the limitation period or adverse possession. And the court held that a brother cannot make this claim against his sister in cases of inheritance. This played very important role in opening up or widening the a right of inheritance of females. The right of inheritance of females in Pakistan remains a very controversial issue, not only because of social context, but also because of political context. In Pakistan, many politicians, their source of power or influence comes from the property held by them and their families. And we have seen that there has been this a business class, just like Nawaz Sharif and different other families in Punjab and also in Sindh, whose base is industry and business. And there has been this tussle between traditional landed elites and this new rising business class. And for the time being, it's the business class that is trying to take over the traditional landed elites. And apart from uh, genuinely applying Islamic inheritance law, there is this political context. So, Pakistan Penal Code was amended in 2011 when Section 498A was added to the Pakistan Penal Code, that depriving a female of their inheritance right is a criminal offense. That was when Pakistan a Muslim League was in power. Similarly, in 2012, Punjab regulations which provide that whenever a person dies, that person's property is automatically transferred to that person's legal heirs. These are some of the these are some of the these are some of the acts or some of the steps taken by the ruling business elite in Pakistan, geared at um, uh, uh, um, geared at weakening the economic base of traditional landed elite. Once properties is divided, then the breadbasket of the family or the power bases of the traditional landed elites would be hit very hard. So while we are studying inheritance law, we must keep this political context in our mind in order to understand the actual practice of inheritance law in Pakistan.